Here for oral argument in our case, CV19 0684, Silva v. Silva. Counsel, you each have 20 minutes for your argument. The appellant can reserve time. I would just ask that you do that yourself. I don't know if we're doing it up there at the we've sort of been going back and forth and allowing you to
do it where the microphones are for the recording.
Right. So either way, use the clock to keep track if you want to save time. We've read the briefs and conferenced it. I would ask that you keep that in mind when you argue. And with that, let's get started.
Good morning, Your Honors, Counsel, and may it please the Court. My name is Michael Dinn, and I represent the appellant, Jose Fernando Silva, in this case. Of the three issues raised in this case for appeal, I will start with the disclaimer deed issue. The trial court below erred by characterizing the parties' marital residence as community property in this case, specifically under our court's precedent in Bender v. Bender and Bell-Kilbourne v. Bell-Kilbourne. This is because there was a valid disclaimer deed that was signed by wife never alleged fraud or mistake below, and thus the trial court was compelled to give the deed full effect absent fraud or mistake, and it failed to do so and instead focused on the nature of the funds used.
Counsel, go ahead.
What kind of pleading requirement is that in a family court in response to a disclaimer deed? I mean, I guess you don't have the equivalent of some sort of Rule 8, right, where you either preserve or waive.
Well, taking this court's cases in Bender v. Bender and Bell-Kilbourne, for example, the courts repeatedly stated that if you're going to raise affirmative defenses, which would be fraud and mistake in this case, and which Bender directly dealt with, that they have to be both pleaded affirmatively with particularity and then proven by clear and convincing evidence. And if you take that together with Rules 24 of the Arizona Rules of Family Law Procedure and Rules 29, both of those govern when, how, and in what documents such affirmative defenses, any defenses really, must be raised. So turning to the legal analysis in this case, it's essentially a three-step process. The first step is that any property acquired during a marriage is presumed to be community property. But a spouse claiming to the contrary can say, this is my sole and separate property, but then they must do so by clear and convincing evidence. So taking Bender together with Bell-Kilbourne, this court has continuously held that a valid disclaimer deed is sufficient to rebut that community presumption.
Wasn't there a dispute, though, as to the validity of the deed below? And should we or could we read the court's ruling as finding that your client failed to meet his burden of establishing the validity of the disclaimer deed?
To the first part of your question, Your Honor, the answer is no, because the issue was never raised below.
Well, she testified that she didn't sign it and didn't know even what it was, which I realize are two separate things. But as to that first one, her claim that she never signed it, why isn't that something that we can infer that the court found that this wasn't a valid deed?
I think this court addressed that issue in Buckholtz v. Buckholtz, where the court noted that in the very last page of its opinion that stating that you didn't do something just at the process of trial without pleading throughout the proceedings or talking about it isn't substantial enough or doesn't constitute an effective way to raise an affirmative defense. And in that case,
but isn't that this? I think this is different than an affirmative defense. The affirmative defenses are fraud, mistake, whatever. But saying that's, you walk up with a deed and I say, never seen it before, never signed it. That's not an affirmative defense. That's saying you've got now the burden to prove that I did, right?
I'm not sure I quite understand Your Honor's question.
Okay. You present a document, whether in this case a deed, and you say, Judge Moore signed this, he's signed over his house to me. And I say, no, I didn't, never signed it. What is a court supposed to do with that case?
Well, I think the court would rely on the disclaimer deed itself, which in this case is Trial Exhibit 4, which shows that she signed it, and it's notarized, and it was filed with the county recorder's office the next day. And getting back to Your Honor's...
So at that point, then, That's sufficient to find that there is a valid deed, is your position?
It
The fact
is.
it's been notarized and all those things, and the court impliedly must have found that it was actually signed by her.
Yes, Your Honor. And the reason is because she never attempted to even, she never pled, she never attempted to prove that this deed was the result of fraud or mistake, and it's incumbent on the party to do so.
That's step two. I'm just trying to get to, because you've said the word valid disclaimer deed has certain things. Again, I'm saying, so we have a record here. There's no dispute that it was valid.
There's no dispute that it was valid. If you look at the trial court's opinion of the decree of dissolution, specifically on page 3, the court solely focused on the nature of the funds for making its determination that the home was community property. If you look at page 2 of that same decree, when it's doing its ARS, when the court, that is doing its ARS 25-318 analysis and how
You
it
mean
can...
page 4, I believe, right?
Oh, I beg your pardon, Your Honor.
It starts at the top, bottom of page 3, okay.
So if Your Honors look at page 2 of that opinion, the court notes that it can distribute the property, not that it has to do it substantially equally in accordance with this court's precedent, but it doesn't have to, as long as it's equitable, it doesn't have to be substantially equal based on the specifics of each case. And one of the reasons the court notes that it can do that is if there's fraudulent disposition of property. Now, if the court were going to find fraud were applicable in this instance, which was never before it and it never made any determination on, it would have made that analysis right there in that specific sentence. Instead, it goes on to say that this is not a unique set of circumstances that requires a substantial or an unequal division of properties to comply with this court's mandate.
So, as I read the court's order, the court had found that the disclaimer deed, although I guess your position would be signed and notarized, et cetera, was invalid because of the attestations on the front of it. That his allegedly false statement that it was separate property that went into the payment made the deed invalid. Why is that a wrong ruling?
It's wrong because the court focused on the nature of the funds. And when, as this court kind of explained in Bender and Bell-Kilbourne, when somebody signs a disclaimer deed, they're in fact signing away any interest that they had in the property that's been purchased, along with the cash used to procure the home. In Bender, for example, the court stated that we must give a contract a disclaimer deed its full effect and hold that the property in that case was correctly determined to be the sole and separate property of the husband there because as was the cash used to procure that property. So taking that together with Bell-Kilbourne noted that that Bender didn't really necessarily focus on the nature of the funds used, and that's because when somebody says, like in the disclaimer deed here, which is virtually identical to Bender and Bell-Kilbourne's disclaimer deeds, that the property above described as the sole and separate property of the spouse having been purchased with the separate funds of that spouse. That's why the trial court erred, because essentially wife here has contracted away her community interest in the down payment of the house.
In the funds.
In the funds, that's
Okay.
correct. So going back to the legal analysis of this case, there's essentially the 3-step process. I made it to step number 2, which is you can rebut the community presumption, which husband did in this case with the valid disclaimer deed. Then it's incumbent on wife to come out and plead and then prove an affirmative defense, which would be fraud or mistake. Wife never did that in this case.
Let's assume that I agree with you that the trial court didn't apply the proper presumption rebuttal type of standard. We'll also assume, for purpose of argument, I disagree with you that it had to be specifically pled, that the wife could have just raised it by saying that this was fraud and I didn't know what I was signing and it was either fraud or mistake. Would you agree that we are supposed to affirm if the record supports that basis, even if it wasn't the basis explicitly stated by the trial court?
No, not under this court's precedent, Your Honor.
Which precedent would you rely on to say?
I would rely on Bender, Bell-Kilbourne, and this court's most recent decision in Femiano versus Moss, where the analysis is all the same, that if there's a valid disclaimer deed, that rebuts the presumption, and absent a showing beyond clear and convincing evidence that...
Right. I'm sorry, I didn't ask my question well. There's a general principle in law that we affirm for any basis supported by the record below. So even if the trial court said, I find this is invalid, which assuming that I agree with you that that was an error. Why couldn't we affirm if we can look at this record and determine that there was clear and convincing evidence of fraud or mistake below?
Well, I think that, Your Honors, that would be a factual determination for one.
But didn't the trial court make that factual determination? I mean, they determined that he made a false statement with respect to the source of the funds. And why isn't it just impliedly supported by the record that she detrimentally relied on that false statement in signing
The reason is because she never alleged the fraud or mistake. And I think, going to Your Honor's direct question, it would undermine not only the court's precedent here, but also the rules of procedure. And in the end, it goes really to this court's, our court's in Arizona's standard that litigants are held to the same standard as attorneys. And everybody is required to be on notice of the statutes and rules of procedure. And to follow Your Honor's logic would essentially undermine all of that.
Okay. Why wouldn't we, though, say that, you talk about holding him to the same standard. Didn't your client miss the, or late notice the disclaimer deed altogether? I mean, if we're going to hold her to standards as far as pleading and raising defenses or affirmative defenses, my understanding of the record is that he did not properly disclose the disclaimer deed until after the time had passed for doing so. Or am I misremembering the record? But judging from the expression on your face, I think I might be, but go ahead and tell me I am.
Could Your Honor clarify what you mean by late disclosure?
Well, he didn't include it in, and let me look at my notes here. He did not file a pretrial statement, and he did not disclose his exhibits prior to trial. The only pretrial reference to the disclaimer deed is one mentioned husband's resolution management statement. So that's not normally what we would expect of an attorney in a situation like this.
I understand your concern, Your Honor, but disclosing it in the RMC statement was well before trial, months.
But he didn't actually provide her a copy of it or exchange the exhibits as we expect parties to do.
The record seems to indicate that, Your Honor. It's unclear with the faxing going back and forth of what actually happened, but disclosing it at...
He mentions a disclaimer deed, but doesn't provide it to her. She doesn't know what it is, and you're saying, well, we should hold that against her. We should hold the fact that she didn't say fraud and mistake in some type of affirmative pleading or defined argument when the actual deed itself was only disclosed to her on the day of trial.
Well, Your Honor, this would overlook the fact that she actually has knowledge that she signed it. She was there when she signed it. It's notarized. It's recorded. And the fact that that husband provided it to her or provided knowledge of the claim in his petition, although he didn't say that I'm going to rely on the disclaimer deed, he did throughout claim that the house was his sole and separate property. And combine that with her knowledge that she actually signed the document is sufficient.
So there's no undue surprise because she must have signed it since it was notarized.
And she'd never pleaded fraud or mistake, Your Honor.
But she did deny signing it.
She did deny signing it on page, I think, 97 of the transcripts.
Right.
I think the court specifically asked her, do you have anything you want to add about the disclaimer deed? And she said no, but then stated, I didn't sign any documents in this case.
I've been monopolizing your time, I'm sorry, and I'm sure you want to reserve some. Are there the other issues beyond the disclaimer deed you want to talk to us about?
I would like to jump in and talk a little bit about wife's arguments. I believe I still have 6 minutes and 50 seconds.
Yeah, I was just, in case you wanted to reserve some of your time, I was
Well, thank you, Your Honor.
telling you I'm letting you off the hook now, so go ahead.
Essentially, wife's arguments here are, the first argument that is that the court could have found that 4 different affirmative defenses could have applied in this case, and those are constructive fraud, common law fraud, mutual mistake, and unilateral mistake. And there's 2 fundamental problems with these claims, Your Honors. And the first one is the speculative nature of the claim that itself is essentially operates as a concession that wife never pleaded or attempted to prove fraud or mistake or any of these 4 affirmative defenses at trial or interpleadings or at trial, and that the trial court never made any findings on the issue. To support that point, wife never noted in her answering brief any citations to the record of where fraud or mistake was pleaded or where the trial court made a determination on that issue. And because those issues were never raised, these four issues in specific were never raised with the trial court properly, this court should consider those issues waived for purposes of this appeal. And I think this kind of gets back to your point, Your Honor, is that even if we were to imply or read into the trial court's decision of finding a fraud or mistake, it fails under the Buchholz case that we talked about earlier. And I know that Buchholz dealt with equitable defenses, but that case specifically cited to a case called Reed versus Hinderland that noted affirmative defenses had to be pleaded and then proven beyond clear and convincing evidence. So that standard applies just as well as it does to to equitable defenses in this case, Your Honors. And I think that case also stands for the proposition that statements made at trial, such as what Your Honor and I were just talking about, of saying I never signed any documents, aren't sufficient to raise an affirmative defense in this case. It has to be pleaded and proven under this court's precedent. Wife's next argument is that affirmative defenses do not need to be pled. Well, first of all, this overlooks the fact that it has to be proven beyond clear and convincing evidence. And second, it also overlooks the fact of our pleading standards in Rules 24 and 29 of the Rules of Family Law Procedure, as well as the propositions that our courts have set forth, the precedents that the courts set forth that these defenses need to be pleaded and proven beyond clear and convincing evidence. And wife's next argument is a public policy argument, and the argument goes is that since these litigants were pro se and relied on the court forms, wife should be given leniency because the court forms don't specifically prompt one to plead affirmative defenses. And this argument's undermined by the fact that pro se litigants are held to the same standards as attorneys in Arizona, and they have to be on notice of the statutes and rules. And it also overlooks that this deed is virtually identical to the one in both Bender and Bell Kilbourne, and the court should give effect to the disclaimer deed. And it would, from a policy standpoint, it would implicate numerous other deeds both in the past, present, and future, because this standard form deed has been relied on at least since Bender, which was in 1979, and it's obviously still in use today. And finally, wife argues that even if this court were to find that the disclaimer deed was valid, it should still affirm because any error in this case would be harmless. Your Honors, I think it could hardly be said that it would be harmless error in this case because on the one hand, we would have a valid disclaimer deed, an enforceable contract, and then on the other, we're saying that the deed is meaningless and that husband is required to sell his home. And moving on to the other two issues raised, which would be the property allocation, the community debt allocation, which was 80-20 to husband, and then the evaluation of the Dodge Caliber, we respectfully request that this court vacate those orders and remand for the trial court because the court abused its discretion because it's a misunderstanding of fact on both of those issues. And I would respectfully request that I reserve my remaining time for rebuttal, Your Honors.
Thank you, counsel.
Thank you.
All right, with that, we will go to the appellee. Counsel.
Good morning, Your Honors. May it please the court. I'm Randy McCaskill on behalf of Beatrice Silva, the respondent here, or wife, as we'll talk about. This case really involves two fundamental questions about can people rely on Rule 97 of the Family Rules of Procedure and rely on the forms that our Supreme Court said are good and reliable and satisfy the rules. Essentially, it's an access to justice issue for people who are unrepresented. And as this court looks back through the record and looks at the forms, it will find that the pleading requirements that husband urges here under Rule 24 and 29, they aren't dealt with in the forms. And so
Counsel, and I hate to interrupt.
No,
early on.
please.
Why don't you finish your thought and let me
No,
let you
please,
get in
go
a
ahead,
couple
Your
minutes, and then I'll jump in.
All right. So essentially, this court pits two sets of rules against each other if you follow husband's train of thought. It creates procedural combat, and it creates procedural combat for people who are utilizing the forms. And certainly in this case, both parties exclusively utilize the forms. And when we get to the substance of the matter, as Judge Morris says, as you pointed out, the petitioner here, the husband here, did not plead in accordance with Rule 24. There's no complaint. There's no allegations of fact. There's no then subsequent denial of this. This is not a civil procedure type of a pleading situation. These are form documents that unsophisticated people in this particular case relied upon, and they filled them out the best they could.
Let me now, sorry. Assuming I agree with you that there's not the same heightened pleading standard in family law cases that we would apply in a regular civil case as to fraud and affirmative defenses. But we have so much case law that says there still has to be, fraud has to be alleged in some way with specificity. So even if I say you're right, she doesn't have to put on a form, I don't see a way around saying she's got to at least stand up in court and say, hey, here was fraud, here's the false statement, here's he knew it was false, or the constructive fraud elements, and here's how I detrimentally relied on it. And I don't see that anywhere in this record.
I understand, Your Honor. I mean, think what happened here, and as you pointed out earlier, husband didn't turn over the disclaimer deed until the first 5 minutes of trial. So you see that on page 5 of the transcript. He provides Judge LaBianca with a folder full of documents. And she asks, have you provided this to your wife? No, is the response. So she's never seen this ahead of time. For her then to articulate the standard that you're seeking her to do at trial, she certainly did not do that. She did not walk her way through a fraud claim. With all due respect, I don't think she probably knew the elements of fraud. She was certainly surprised at trial with respect to the matter. Judge LaBianca certainly understood that situation, certainly asked questions about whether the wife believed that
She doesn't dispute that the husband disclosed the existence of the document. It's your position is that she was free to disregard the disclosure of the existence of the document earlier, pending trial, or I guess I'm trying to
Your Honor,
figure out exactly what standard. Are there any standards?
I think there
at play
are
here?
standards, Your Honor, but in this particular case, you'll take a look at the record, and the husband does not disclose the disclaimer deed ahead of time. He certainly doesn't do it within the pleadings originally in the case. And as the record shows, as the transcript shows, he acknowledges he never disclosed it or turned it over to wife.
When you say he didn't disclose it, you mean he didn't disclose the physical document itself. I guess what I'm getting at is I understand that he did disclose the existence. He referenced it ahead of time. And if you take together the reference to the disclaimer deed, wife's signature on it, and the notarization, isn't there any presumption that had she had some question about it, she would have raised that or requested it or said, I don't understand what you're referring here. But the fact that she didn't, coupled together with her notarized signature, suggests she was actually aware of this document previously.
So, Your Honor, her testimony at trial was that she didn't sign the document, that she never intended to let almost all of her assets be swept away for no consideration, for nothing at all, so that husband could take that. In fact, husband admits during his testimony that he intentionally secreted this whole plan. It was a whole scheme in order to divest her upon divorce. But the question, I think, with respect is what is she required to do? And I think that with respect to the disclaimer deed, and Judge Morse pointed this out to some extent, Judge LaBianca was looking about the validity of the deed. The recitals are false, patently false. That's not in dispute. She didn't intend to provide a gift or to give away anything. With respect to that issue, I think that Judge LaBianca gets at that in her decision. What she looks at is a contract basis of whether or not the deed fulfilled the contract requirements. I mean, if you look at the Buchholz case, that's certainly what the court did. It looked at those items of, is this a valid deed? Was there consideration? Was there a meeting of minds? Was there an offer and an acceptance? And I think that's what Judge LaBianca did in part here. But what she also explored is whether or not that the intent of husband, and husband admits this, whether his intent was fraudulent or to cause a mistake. And as I point out in the brief, any of those theories follows through with respect to looking at the record here. And as you pointed out, Your Honor, the standard of review to this court is to look at the record and see if there are any facts to support any of these theories, because husband did not ask for a reasoned decision. He was obligated to, if he wants to come to complain to this court, that one wasn't given. But one wasn't given. There was a recitation very quickly with respect to the validity of the deed. And I don't think Judge LaBianca is express with respect to how she found that, whether that was invalidated under contract law or whether she invalidated under fraud or mistake. I think that's left open. And certainly this
Let me interrupt you there, because I think you're right. But I think that leads me to a different conclusion than what you've concluded. And I can't find, except for one reference to fraudulent disposition of property, which is about equitable distribution, is not related to the assignment of whether property is separate or community. I can't find the word fraud or mistake anywhere in her order. So based upon that, I'm having a hard time saying, as you point out in your brief, there's a lot of could or shoulds, but there's not any is.
Well, I agree, Your Honor. And that's certainly, there is a discussion of fraudulent disposition, but that's only in the discussion of an unequal division of property.
Right, so
that doesn't apply here. There wasn't an unequal.
So I can't find anything in here to support the notion that Judge LaBianca applied what I view as the two-step analysis.
Right.
Did he rebut the presumption? I think the case law, even if deed with false attestations on it, the case law suggests that meets the presumption of a facially valid deed. And you can kind of apply that. I've seen lots of deeds when I buy a house, it says for 10 cents and other good and valuable considerations. That may be false or not, but that doesn't defeat the deed. And so then we're left with, well, what do we have here? And I don't find either side's waiver arguments particularly compelling. I think that we're kind of left with a incomplete decision. So to me, isn't the remedy, your remedy that you suggest is kind of an alternative or fallback in your brief, which is we need to send this back to the court. You can raise, or your client can raise the fraud defense or mistake defense, which seems to be supported by the record, but it's a clear and convincing standard, and we don't have findings to support it.
Well, Your Honor, I don't think this court needs specific findings on that issue. The court's standard of review is to look at the record and see whether there is a plausible pathway to Judge LaBianca finding those things existed.
If she had said this was fraudulent, I wouldn't say that we need findings as specifically as to each element, but I can't tell that she even applied a standard that would say that she found fraud. So how do I affirm a decision that she didn't find?
Well, Your Honor, I think under this court's precedent that where the judge doesn't provide an explanation, the court must assume that there were theories that the judge looked at, and if facts support that, then the decision is legitimate. Rule 82 here provides the solution to husband's complaint, which is there's no findings of fact. But in this court, where a trial court judge does not provide a reasoned decision, which happens all the time, of course, this court's charge is to look back at the record and ask itself, are there any facts that substantiate the judge's decision under the various legal theories at play.
Let me press you on one of those. So under fraud, you have to show that the statement is false. And we do have a finding that there was a false statement, I think. I can accept that. But there's a whole bunch more there. So what is the husband denied knowing that the separate property was, or that the payments were community property as opposed to separate property. He said, well, it's my money. I thought it was separate property. Under fraud, it has to be that he knowingly made that false statement. So how are we supposed to conclude that he knowingly misled her as opposed to just was mistaken as to the law?
Well, I think that if you take that track, then it clearly places affirming the decision under the mistake theories. In that situation, husband made a mistake, wife made the same mistake, there was reliance on that, and the parties carried through. So what you've described as mistake instead of fraud. So, and I think that the constructive fraud theory is particularly important for the court to take a look at because this court has not taken a look at it in this context. And certainly the Bender case and the Bell-Kilbourne case, they never get to this. In fact, they don't get to where the money came from or any of that. And I know the Bender case is cited a number of times by the husband. That case is 2.5 pages long with 3 issues in it. It is a very, very short discussion.
It had to be before word processors, right?
Well, it's 1979. All the cases otherwise, by the way, that are cited here all involve procedure that didn't exist at the time of this trial. It was the prior rules of civil procedure or family law rules. I'm sorry, Judge Perkins. I know I've stepped on you.
This is an area of that can be troubling in a lot of our case law, but while we do look at the record and we do look for support for the judge's ruling, we are also explicitly forbidden from reweighing evidence. And to some degree, it seems like a little bit of what we're talking about here is asking us not just to go look in the record, but to take the pieces of evidence as to mistake versus fraud or the validity, the disclosure, all of these pieces, and reweigh them and see where it all comes out. But isn't that kind of asking us to invade the province of the trial court when the better result in a case like this where there's a question about what the judge was doing and what was the clear basis for her decision, to give it back to the trial court to make that clear?
Well, I think that the trial court gave you enough to go on here. Okay. I think in her decision, she cites that the funds were purchased with, the house was purchased with separate property. So this is very much like Fimiamo, but it's a little different. Here, the judge is found on behalf of the wife instead of the other way around, and so the standard of review is different. But she also says that the husband testified the down payment of the mortgage were all paid from money earned during the community, produced no evidence of an agreement or other facts to support the finding the earnings during the community would be deemed husband, sold, and separate property. So what she's headed at, I think, is a contract type of look at this, but she's also looking about whether or not there's mistake. She asks a number of times during the hearing about what was the nature of this, what did you believe? And the husband goes on and on and on, very chauvinistic way, which happens all the time in a family court, which is all the money earned is mine. And so I think that there are enough nuggets here within her decision for this court to go back in and not disturb her factual findings, but to take a look at whether or not that those items in the record before the judge would lead her to conclude that this is not separate property. The disclaimer deed is not valid. And so that's kind of where I think we're headed here. I wanted to talk about for a moment this affirmative defense piece. The Supreme Court put out forms. Those are available everywhere. If this court wants, or if the Supreme Court wanted litigants to come in and have this kind of very formalized pleading of of fraud or mistake and lay out all the elements. It certainly didn't provide that in the forms. And Rule 97 says these forms satisfy all the rules. And so with respect to that thing, counsel said, look, we don't give forgiveness. Everybody's, must follow the attorney standard. Well, the attorney standard here, I don't think is in play because the rules provide that the forms are good enough. So let me turn back to a few other small questions. We talked about the wife saying, I didn't sign this deed, but also I think it's important is that she expressed that her intent was not to give away the property. And that particular intent falls then within the rubric of mistake, both unilateral and mutual mistake. The issue of harmless error, and this goes back to whether or not we should just simply remand this back to the court. Husband concedes the right thing to do here with the house is to split the equity. Under Femiamo, that's what would occur if it went back and the deed was not found to be procured by fraud or mistake or wasn't valid to begin with. So if the result here is equal division of the house and both parties agree to that, I'm not certain how harmless error isn't at play here. I know counsel said it's not, he was going to be forced to sell the house, but the testimony here is husband does not have any funds to pay her off. He didn't have a working job at the time, and the equity of the house couldn't be established. And the judge set up a process for that and a special master in order to sell it. Whether it should be sold and the proceeds split is not at issue. So at most, even if Judge LaBianca wasn't correct in how she went about this or could have improved how she entered a ruling, there's harmless error. And this court doesn't send things back when there's harmless error. And I don't see, and husband hasn't articulated how he's damaged with respect to something he's already consented to. So, lastly,
If it was separate property, I want to play with that for a second. If it was separate property and the court erred in finding it separate, or community, but that the community then had a lien against it for the entire value so that she would get 50%.
yes, Your Honor.
Could the court order it sold in that way?
Yes, I think it could, because at that point, the husband needs to pay her. He has already testified he has no means to do so. When the court takes a look at division of property, it looks at equitable division even of separate property. So if the separate property is brought in, the case escapes my mind, but it's cited here in the briefs. If the court looks at all property brought in and then decides how to equitably divide all that, whether there's fundamental fairness with respect to that, the court's empowered to cause the sale of the house. Otherwise, what would happen is the court would say, husband, you get the house, but the community has an equitable lien. And the husband then just doesn't pay it. And so wife then has to file a civil suit to enforce the judgment. And what's the result of that civil suit? The result of that civil suit is to compel foreclosure and to sell it. So the result is the same. We're just cutting down the amount of process to get there.
Thank you for your time.
Thank you, Your Honors.
All right. Thank you very much for your argument, and let's go back to the appellant.
Yes, Your Honors, I have two brief points on rebuttal. And the first one is that if you read the trial court's decision in conjunction with the trial transcripts, and I believe it's at page 56, the trial court's decision here had nothing to do with fraud or mistake and had everything to do with the nature of the funds. The trial court's ruling is clear that it made the determination that the property was community based on the money earned during the marriage and the fact that there wasn't a prenuptial agreement in place to alter the nature of those funds.
You said that was clear?
I believe it's clear from the record, Your Honor, on page, I believe it's page 56, the court notes
But
that.
is the minute entry clear?
Well, if you look at the second sentence where it says that the nature of the funds used for the down payment, and there was no agreement or otherwise, or anything else provided in that circumstance, that presumably the court is referencing a prenuptial agreement in that statement when you
Okay,
take
so
it.
the word presumably is inconsistent with clear. But let's talk about whether you can have fraud as described the way you're describing it, which is the source of the funds. Is that what you were saying, that the court had? The court's decision was premised upon a description of the funds, you had said?
The nature of the
The
funds.
nature of the funds.
Because
right.
it was then earned during the marriage, and I apologize.
Right. Couldn't the nature of the funds, couldn't that mean that it's fraudulently captured in the disclaimer deed as signed? Meaning, in the disclaimer deed, father signs it, and it says he's paid for it with his own separate property. Is that right?
That's what it says, yes.
Okay, and that was not accurate.
I beg your pardon?
That was false?
It's not false. It says that it's purchased with his own separate property, and the disclaimer deed gives effect to that statement.
So there's no evidence in the record that rebuts that, or that he paid for it with his own property?
Well, that's what the parties contracted to, Your Honor. The parties contracted that the down payment was money used to procure the house, as this court noted in Bender.
But the contract that you're relying on for that is the disclaimer deed itself.
That's
There's no
correct.
separate contract that says, hey, you get to keep your money you earned during marriage.
There's no contract within the contract, Your Honors.
Do you have anything else?
Could you respond for 20 seconds, and I guess we can give you 20 seconds if we need to the harmless error argument?
The harmless error argument, Your Honors, is that in one instance, we would have a home that would be his sole and separate property, and I know counsel stated that he didn't have the funds to essentially effectuate a refinance, but he should be given the opportunity to do so under this contract. In the end, it is his sole and separate property, and to decide otherwise would essentially undermine the effect of a contract.
So instead of ordering him to sell it, it is theoretically possible that he could refinance the house and pay her out of the proceeds of that, or at least her share of the equity.
Absolutely, Your Honor. He should be given that opportunity.
Do you want to respond to that? I'm sorry.
Yes, Your Honor. The record before the trial court judge was that he could not. And so I think that we have to take the decision at the moment that it occurred, whether he has a job now or not. I don't think that matters. The last thing I think is not with respect to the merits of the case, but with respect to the gratitude of my client, and I'm sure yours, for placing this matter in the pro bono program. My client is extraordinarily grateful that the court took that position, and I think we're grateful that the program exists.
Well, let me talk for all three of us and say we're grateful for both of you and your service, and this is a critical function, and it wouldn't happen without you. So it means a great deal to us, as well as your fine advocacy. And with that, we're done and adjourned. We'll have an order out in due course.
Thank you.
Thank you.
Thank you, Your Honors.